As many of you might know, UNHCR is interested in this topic because we are operationally engaged, working closely with states and other partners in all of the areas where private actors are concerned that have been mentioned in the research today: immigration detention, border management, transportation, including removal and deportation, and interception at sea, as well as at land and air borders. As many of you might know also, UNHCR, the UN Refugee Agency, acts with a specific mandate from the General Assembly to provide international protection to refugees and to work with governments to try and seek durable solutions for their displacement. We're also responsible under international law for supervision of the application of international convention for the protection of refugees, which includes also using other bodies of law to seek to protect their rights. Under the 1951 Convention relating to the status of refugees, states also have an obligation to cooperate with UNHCR, which includes a requirement, firstly, to provide information to us about the conditions of refugees, as well as affording UNHCR access to them, including whether refugees or UNHCR seeks such access. Unfortunately, these are rules which too often are not respected in practice. I want to speak today about some of the other legal principles and standards in play in this area, including with respect to detention of asylum seekers and migrants in particular. Many of these are also, however, relevant more broadly to the other areas where private actors are concerned. I'd like to recall that states' responsibilities under international law apply also where they engage private actors in the administration or the enforcement of immigration and asylum rules. States are not permitted, as a matter of law, to contract out of their obligations under international refugee or human rights law. They remain accountable for them, for abuses of these laws where they are breached. There's a well-established principle that states have a duty with respect to the treatment of foreigners on their territory to exercise due diligence by taking reasonable measures to prevent, or, if violations are alleged to occur, to investigate, punish, and provide reparation for such violations, whether those are at the hands of state officials or private parties. The International Law Commission's articles on the responsibilities of states for intentionally wrongful acts provides that the conduct of a person or other actor shall be considered the act of a state under international law if that actor is acting on the instructions of or under the direction or control of the state in carrying out the conduct. So the key point here is that if there are breaches of international human rights or refugee law that are occurring in detention or otherwise at the hands of private actors engaged by the state nonetheless retains responsibility for that. But the private actors themselves carry legal responsibilities. They may be criminally responsible for such harm, bodily harm or otherwise. Under tort law, they can also be liable if they are deemed to have engaged in intentional or negligent conduct which results in harm, and they might be liable for damages, potentially enormous damages. They may also, and they should, carry contractual liability. This is because, as part of that due diligence obligation that states have, they need to include in contracts with private actors obligations to respect standards of treatment, with consequences for breaches of those obligations, including potentially contract termination, damages, and other outcomes. So what's going wrong? The law is not ambiguous in this sphere. We clearly have a significant problem of enforcement and of accountability, and it's one which all actors serving in the field have a responsibility to seek to address. I would argue that this means that states and private partners have an overwhelmingly strong interest in being aware of the standards that are applicable and ensuring that mechanisms are in place to ensure they are respected. This includes not only human rights standards, but also specifically refugee law. And I think that's important to recall today because, of course, we have spoken much about migration and migration management. But for asylum seekers and refugees, there's an additional set of legal obligations and duties that goes beyond the general human rights framework, which applies to all people on the move. Refugees are people who are unable to claim the protection of their state. So international refugee law binds states to provide them with international protection, including from exposing them to risks of torture, inhuman or degrading treatment or punishment, as well as being sent back to such risks in the course of deportation, removal, or denial of entry at borders. Turning specifically to the area of detention, UNHCR in 2012 issued detention guidelines, which are widely known and referred to, including by courts and tribunals worldwide. And UNHCR has cited those guidelines frequently in our interventions before regional and national courts, where we've succeeded in challenging unlawful conduct and where we've had rulings that have bound states either to end the termination of individuals or to change their practices and conditions. Those guidelines make clear that asylum seekers arriving in a country where they seek protection should, in the first instance, enjoy freedom of movement. This is the default position under international law. The detention of asylum seekers can only be a measure of last resort. Alternatives can include use of no or less far-reaching restrictions on movement, which might include reporting requirements, curfews, semi-open detention, semi-open reception. But all of these need to be considered before detention is resorted to. Detention can only be resorted to as a matter of law where it is determined to be necessary, reasonable in the circumstances, and proportional to a legitimate purpose. These are very high bars according to international jurisprudence. The criteria for detention have to be enshrined in law, and a decision to detain must be reviewable by a judge or tribunal. Detention can only be for a limited time, and it needs to be in adequate conditions. And these are also questions which need to be justiciable before courts. UNHCR's guidelines on detention are directly relevant also for private actors. Amongst others, Guideline 8 stipulates that conditions of detention need to be humane and dignified, access to adequate medical treatment, to psychological counselling, regular contact with relatives, physical exercise, the right to practice one's religion, access to information, and other facilities. Furthermore, the special circumstances and needs of individuals have to be taken into account. And children are crucial in this respect. Children should generally not be detained under any circumstances for immigration-related purposes. The Convention on the Rights of a Child provides that a child's best interest must be respected in all dealings with them, and UNHCR maintains that detention is never in a child's best interest. Appropriate care arrangements and community-based programs need to be in place to ensure adequate reception for children. It's recognised that private security companies managing immigration detention do not generally have the means to provide services to individuals with medical and mental health issues. And so this means it's incumbent on the state to find ways to ensure that such people can get access to such care and facilities. HCR's guidelines indicate that subjecting private contractors to a statutory duty to take account of the welfare of detainees is something that all states should adhere to. This means then that lawyers, advocates, researchers and others also then have a responsibility to seek to call for transparency and for information about the conditions in which people are held so that these can be challenged before courts where necessary. There's been reference to criminal detention facilities, noting that in some cases criminal detention facilities offer better conditions and accountability. And this might well be because in many instances criminal detainees are voters and their families might well be voters. So we need to be mindful that asylum seekers and migrants in many cases can be amongst the most vulnerable because they're disenfranchised and because they are not seen by politicians as people to whom they're accountable. In this regard, it's important to recall under the 1951 Refugee Convention, it's underlined that seeking asylum is not an unlawful act and that people, even seeking to enter irregularly, should not be penalised. HCR conducts regular detention monitoring when we can have the means to do so. And we've observed firsthand some of the severe mental and physical detrimental impact that immigration detention can have. This is widely documented by UNHCR, and we have used this over recent years to promote alternatives to detention, which are in use in many countries in the world. Anybody who's interested in this is welcome to contact us or to look at our detention websites, because we've succeeded over recent years to encourage many states to use alternatives, which are proven in many instances to be as effective in ensuring that asylum seekers refrain from absconding as detention, if it can be shown that people have an interest in awaiting an asylum outcome for their claim, if they are provided with support in the community. We have many documented instances that show that this is a way in which states can keep track of asylum seekers without needing to resort to detention. We have pilots underway in the UK at the moment, as well as established documented evidence of how these can work effectively in Canada and in other countries worldwide. In terms of other tools, in addition to the Code of Conduct that ICoCA has disseminated and which we would support, we'd refer also to the UN's Guiding Principles on Business and Human Rights. These principles recommend that when entering the business of immigration, detention and border management, private security companies have to be aware of the increased risk of violations of rights, and they need to put in place appropriate due diligence policies and processes. We also want to refer to the fact that the UN guiding principles underline that states are required to exercise adequate oversight in order to meet their international human rights obligations whenever they contract with or legislate for business enterprises to provide services that might impact on the enjoyment of human rights. And this goes across the board in different areas in which private actors are engaged by states in the immigration field. So in sum, we think it's absolutely crucial that the many tools which are out there and available to give clear guidance on how detention, but also other parts of migration control can be better managed, are put to use. Research, dialogue and analysis of the kind that has been presented to us today are important ways for those of us working in the field to seek to ensure that there is greater knowledge, understanding and accountability for these observance of these standards in practice. The law is not ambiguous, I repeat. The guidance and documents that I have referred to here today are widely available, and there's no excuse for violations of rights. So all of us working in the field, whether we be researchers, lawyers, government officials, think tanks, academics, private industry bodies and private associations, have a responsibility to seek to bring more attention to the standards that need to be met and ensure that they're respected in practice. Thank you very much.